Welcome to a course on democratic awareness with legal literacy. Today we will be talking about the legal structure of India and also certain legal structures which are available across the world. Now, when you build up a nation, when we build a nation, the state has certain important components. One is a geoterritorial area within which the nation functions or the sovereign functions. Number two is a sovereign who is not used to listening to other sovereigns or anybody politically inferior to it. Sovereign makes laws for people politically inferior to it, and there is a population which is governed by the rule of law. These are the four components of a state or a nation. Now, these nations, as I said, a population which is governed by rule of law and a political structured system on the top of which is the sovereign are the two essential components of a country or a nation. Now, these structures are built on things or norms which are arranged in a systematic manner. They are called legal systems. There are prevalent legal systems in the world like common law system, civil law system, continental law system, sociological law system, religious system, and international law system. So these are the six laws that are six legal systems on which each of the country builds its political structure. India has a mixed legal system. First, let us understand what are these systems. Common law system started in Britain long back when there was a separation from church and the state was promulgating laws. Now, it was found that those laws which were promulgated by the state and imposed on the polity, they did not work well. So the state, through the judiciary, began to take cognizance of the local customary practices which could be accepted as a part of law, which were not against the accepted standards and principles of law. Courts were, in those days, they would move from place to place, and eventually they were stationed in England, London to be very specific. Now, these courts had judges who would take into account the practices and usages of the common man and try to integrate it with the principles of law that the sovereign wanted to promulgate. Now, this system came to be known as common law system, where common people's customary practices and usages were given a kind of a recognition, and they were incorporated and integrated within the formal shape of the law. This common law system sometimes was also not doing justice, so that the king he delegated the chancellor, the priest to whom he used to confess, the chancellor, to look into certain matters and do justice according to the requirement of the situation. Those courts came to be known as chancery courts and eventually the equity courts that again later merged with the common law courts. So this is the common law system. Common law system is significant in the fact that common law is an open system where the media, the people, they can openly access the procedure, they can critique the procedure, they can comment on the procedure. This is a very important aspect of common law system. It is an open system. The other important aspect of common law system is the system of precedent, where the judge of the highest court gives out a judgment which is binding on all other courts in the country. And the high courts, their judgment is binding on the courts within that state. But the Supreme Court's judgment is binding on all courts across the state. Now, this is very important because it keeps a consistency of the law. In similar situations, the thinking pattern of the judiciary is very clear, and the people, including the lawyers, are able to understand the drift in which the judiciary is thinking, or the minority judgments who were trying to usher in a kind of change, they can also be taken into account. So this system of precedent, otherwise known as doctrine of stare decisis, is a very significant aspect of common law system. Another important part of the common law system is the precedent. The reasoning and the judgment of the court is known as ratio decidendi, and whatever is said aside, which is not part of the judgment but equally important in the framing and development of law, is known as obiter dicta. Now, common law system, the other system as against common law system is the civil law system. In civil law system, we have the law promulgated by the parliament and the legislative assemblies, or whatever it is known by, and that is imposed on the people. Here the judges go by the letter of the law. In common law system, there is a scope for harmonious construction, and the judges can look at the spirit of the law. But in civil law system, it is strictly the letter of the law, and judges go by the letter of the law. There is no precedent there in the civil law system. Judges are not bound by precedent. It is another matter that in reality, at the ground level, the judges do look up the previous judgment of the court and try to draw from those judgments. But strictly speaking, formally, they are not bound by precedent. And law is imposed upon the people as promulgated by the parliament. This is the civil law system. In religious law system, the religious book is the ultimate source of law. Whatever law the parliament makes or the lawmaking body makes, it is tested against the religious texts. And if it is found to be contra to the religious texts, then these laws are said to be null and void. So this system believes that the source of law is divine, given by God, as laid down in the scriptures, and law should be made according to the scriptures that is laid down through the command of the God. One very important example of such a system is the Muslim law system, where Quran, Shariat, Hadith, Sunnah, Ijma, Fiqh are the sources of Muslim law. And any law which is promulgated in a secular manner must be tested against these religious sources. In the continental system, we see it is very similar to the civil law system. Law is promulgated by the parliament and it is imposed upon the people from top. Precedent is not very important in the continental system. In the socialist system, as you know, it was believed that there is a disparity between the haves and have-nots, and the effort is made to bring parity between the haves and the have-nots. And it is believed that once that parity is reached, we will not have any requirement for the state or the law. It is said that the state will wither away. It will just not exist because everybody will be equal and everybody will be happy being like that. The other set is the international law set, where the international community under the leadership of the United Nations Organization have created regional organizations like SAARC, etc., where, and then we had the European Community also as a regional organization, where they have framed their own laws and constitutions, and they function according to their own laws and constitutions. The instruments of the international legal system is the treaty, convention, etc., which is which a nation binds itself voluntarily. As I said at the beginning of this presentation, that the sovereign is not bound by a like sovereign, and neither it is important for the sovereign to follow the diktat of another sovereign. But there are situations at the international level where the sovereign volunteers to bind itself with a treaty or a convention for its own protection and for the good of the world, for human rights protection, for certain achievements in the field of, say, war, prisoners of war, genocide, even environment, so on and so forth. So these are the few systems that are prevailing in the world. India is unique in the sense that India has a mixed legal system, in the sense India has a lawmaking body in the form of parliament or the legislative assembly, where the law is promulgated, and most of the laws have a sanction attached to it. In legal parlance, a sanction means punishment, which is attached to it. But there is also this element of the common law system, because India has a very strong precedent or doctrine of stare decisis, which India follows, where the judgment of the Supreme Court is binding all the courts, and the judgment of the High Court is binding on the courts within that state. Judgment of two high courts have a persuasive value. Supreme Court decides which of the persuasive argument is acceptable, and then decides, upholds those persuasive arguments. So there is a very strong precedent system in India. India looks into the law from the spirit of the law rather than the letter of the law, which is again in keeping with the common law system. Common law system too looks into the spirit more than the letter of the law, unlike the civil law system. Though, like the civil law system, law is imposed from top to the people. Like common law system, Indian system is also open. Anyone can follow the court proceedings, they can sit through the proceedings, they can critique the proceedings, and they can observe the proceedings, and if there is anything wrong with the proceedings. So these are some of the factors of the common law which is available in India. So very commonly it is said that India is a mixed legal system, where elements of common law as well as elements of civil law can be seen. India has a strong community of strong Islamic community, and also there are a minority community of the Christians and Jews. Now, the Islamic community, they do follow the secular laws of India, which is promulgated by the parliament and the legislative assembly. Nonetheless, some of the laws are still evaluated on the anvil of their scriptures and religious texts. India is said to be a federal country, but as we understand the structure of the country, you will see that a large number of power is retained by the parliament in the union list as well as in the concurrent list. The legislative power is distributed in the form of 3 lists in the 7th schedule. The first list is union list, where the parliament alone can promulgate laws. Second is the state list, where the state alone is supposed to promulgate the laws. And the third is a concurrent list, where the state and the parliament both can promulgate laws. In case there is a controversy or conflict between the laws of the parliament and the state, or the area in which the law is to be made falls, the parliament thinks that the parliament will promulgate laws in those areas. In that case, the law made by the parliament prevails. One of the examples would be our recent pandemic of COVID-19, where health situation is under state list, but the union, the parliament took over the leadership of making certain policies regarding the pandemic, which were obeyed by the state, followed by the state, because the parliament's opinion or decision prevails. Even in financial situations, you will find that there is a strong leaning between the parliament and the center and the state, where the center takes a leadership on financial matters, and therefore there is a strong leaning towards unitary government in India, although it is said that India is a federal state. Therefore, India has a very strong unitary leaning. Even in financial matters, in the matters of taxation like GST, there is a large amount of money in the form of central GST, which goes to the central government. There is a union budget and also a state budget. The state budget always follows the union budget. The entire structure of India is federal in nature, because there are component states which are within the umbrella of the union government and the Constitution of India. There are several states in India which have their own generation of revenue, and at the same time they are dependent to a large extent on the revenue received from the central government. So in India cannot be said to be a strictly federal country, because the states are not completely autonomous, and the states are not financially independent, neither are they completely politically independent. Therefore, it is a federal structure, but there is a strong leaning towards the center. Now, coming back to the Constitution of India, Constitution of India begins with a preamble which lays down the foundational principles on which the Constitution is being built. It starts with "We the people of India," which says that the people of India is the sovereign in this country, and the persons elected by the people of India form the lawmaking body, or they are the members of the parliament or the state legislative assembly. It lays down certain very important. Before I go into the important principles, I would like to say the people of India in the past, way back in 1950, and now in 2023, and in future, is a fluid concept. There will be different types of people, citizenship, residents, nationals will be within India. But these people are all bound by the rule of law. They are an organized political body or organized social population. Those who are not within the framework of the rule of law and not within the organized social population are not counted as people of India. For example, the dissidents, terrorists, they are not considered within the concept of people of India. Although the Constitution makes sure that justice is meted out to them. They are given natural justice of audio alterum partem, where they can present their case, they can have an unbiased trial, and the decisions that is taken in their regard is a reasoned decision. They are subject to equity, fairness, etc. All of that is applicable to them, but they are not the sovereign maker. They are not the sovereign of India. Constitution says justice, social, economic and political will be meted out to the people. Liberty of thought, expression and belief, faith and worship will be given to the people. Equality of status and opportunity will be given to the people. One thing it is to be understood that these words which are laid down, first in the form of justice, second liberty and third equality, and the sequence in which it is given, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and opportunity, all are of very much significance. Each one precedes the other, because if you don't achieve the first, you cannot achieve the second. So this is a very important aspect of the preamble of the Constitution. The Constitution also states that the power of ceding or accessing areas, or increasing the boundary of the country or reducing the boundary of the country, is in the hands of the union government. And that has happened, as you can see, in the transfer of enclaves, and in cases of Berubari case. Then we have Teen Bigha area in North Bengal. In all these areas, you can see that the union government has played a very important role, and treaties and agreements have been formed between the two countries, where the country has acceded to land which was land bound by Bangladesh earlier, and now have become part of India. The exchange of enclaves is a very important example of how the union government can increase or decrease the area of India. A very significant part of the Constitution is Part 3 of the Constitution, which speaks about fundamental rights. There are several important fundamental rights, almost 31 of them, which includes equality, which includes right to freedom of speech and expression, right to life, right against double jeopardy, protection against beggar, so on and so forth. There are around 31 fundamental rights which are of very, very great significance. But of the most significant article in the fundamental right, without which the fundamental rights would be of no use, is the right of judicial review under Article 32, which allows a person to litigate for restoration or protection of his or her fundamental right against the government, and the court, under the writ of mandamus, certiorari, prohibition, quo warranto and habeas corpus, can direct the government to restore the rights of the people. Another important aspect, while I am talking about fundamental right, is that of the litigation of public interest litigation, where the locus standi has been relaxed, where anybody can file a case against a situation where a large number of people and their fundamental right is affected by certain action of the government, and the person can litigate on their behalf in the High Court or the Supreme Court. The series of MC Mehta cases and the example of the oleum gas leak, Bhopal gas tragedy are examples where public interest litigations have been instrumental in bringing out important principles of law. So this is one very important aspect of our Constitution, where the locus standi has been relaxed a little to allow people, large number of people affected whose fundamental right has been affected, to come and litigate before the court through a single representative. The other important aspect is that It is called epistolary jurisdiction, where a person who is severely affected and the fundamental right is severely affected can directly write to the Chief Justice of the High Court or the Supreme Court, and the Chief Justice and of the High Court or the Supreme Court, if they think it is right and proper, may take cognizance of that as a writ petition and proceed with the case. This is a wonderful opportunity that is given under the Constitution of India. The directive principles of the state policy, as you know, is also fundamental in the field of governance. Fundamental right is important in the field of personal rights, fundamental rights, and directive principles of state policy are very, very important and fundamental in the field of governance. But they are not justiciable in a court of law. It included right to education, it included right to healthy environment, it included issues that led to avoidance of concentration of wealth in certain hands only. It dealt with issues of legal aid, of economic justice, but all of these were not justiciable. Therefore, it was largely left to the discretion of the state how to and when to implement it. But the Supreme Court has now, through Article 21, termed certain rights as fundamental rights and have lifted them from directive principle and brought them within the purview of fundamental rights. For example, a right to education, right to health, right to clean environment, all of that have been shifted from directive principles. Right to legal aid, that is also termed as right to life, and it has been lifted from DPSP and integrated in the Article 21. Article 21A has become a named fundamental right on education, right to education for people 6 to 14. Now, these are very important aspects of the Constitution of India and of DPSP. Apart from this, the Constitution of India is also talking about the election of the executives, functioning of the Supreme Court and the High Court, so on and so forth. And I also mentioned the center-state relationship a little while ago while explaining how our mixed in the mixed economy and federal structure, there's a strong leaning towards the center. So that being so, there is also the last but not least, that the Constitution of India is the supreme fountainhead of all laws in India, and it ensures that India becomes a secular, sovereign, democratic republic, and that is how democracies function in India. Thank you so much.